I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today, we are continuing our series on building the AI lawyer skill set with a discussion of AI and litigation. This mastery series recognizes that AI lawyers need to know a lot about a lot. And with AI impacting almost every area of law, AI lawyers now need to retool and be able to issue spot across legal disciplines. There's just so much to learn. The Data Chronicles is here to help with this special AI mastery course that includes episodes that cover many legal issues that arise from AI. And today we focus on litigation. On today's episode, I've invited my partner, Vassi Iliadis, to the podcast. Vassi is an experienced litigator representing clients who are subject to large-scale class actions arising when things allegedly go wrong in the digital ecosystem, whether it's cybersecurity breaches, privacy harms, or now AI. With her wealth of knowledge of how our digital lives are being litigated in courtrooms, I'm excited to have her join the Mastery series.
Vassi, welcome back to the podcast.
Thanks so much, Scott, for having me.
So, Vassi, why don't we jump right in? I mean, there's been a lot of speculation and a lot of kind of theories about how AI may eventually find itself subject to litigation in the courts. Interested in your perspective, where do you feel like the most likely candidates will be? And are we seeing anything today?
Yeah, Scott, happy to talk through what the landscape looks like today. And I think this really started becoming more rampant in the court system in 2023. So over the last year and a half, we have seen courts across the US, particularly federal courts in California and New York, grapple with lawsuits challenging the legality and or use of generative AI systems and tools. And one way to think about the litigation is to sort of divide it into two categories. One, litigation about inputs used to create AI systems. And as we know, AI is trained on massive amounts of data. And two, litigation about outputs generated by those systems. And I think over the last year or so, we've seen more litigation about the inputs to systems, and we can talk more about that. And I think on the landscape, we're going to start seeing claims, both from private plaintiffs and regulators, on the outputs generated by those systems.
Yeah, interesting. So let's just maybe think about it that way. So the claims relating to the inputs of data, have those largely kind of been intellectual property oriented claims?
That's right. You're exactly right. So mostly IP disputes, copyright, trademark cases, and the core allegations in those suits is the purported unauthorized use of protected works. The second area, in addition to IP related to input litigation, I would say, is in the privacy space. So we've seen, early AI litigation involving biometrics, for example, and claims that unsurprisingly center on BIPA, the Illinois law. We saw some litigation in 2021 and 2022 related to developers of facial recognition software tools and AI alleging violations of BIPA. And we're continuing to see those types of privacy claims as well regarding inputs and how data is being used to train AI.
Yeah, I mean, that's a really interesting area because, I think as folks who are in the space know, in order to train the AI and then develop the large language models, you need to have access to large amounts of data. And oftentimes that can be scraped data that you get off of the public internet, but it also could be, data that's being collected through a variety of other commercial means. So for example, in the B2B context where service providers are providing different services and collecting a lot of customer data, that could also be a rich area to be able to train AI. Interested from your perspective, right now, it seems like a lot of the cases are around the scrape data or the ability of taking data, journalistic content, for example, and ingesting that into AI algorithms to train them. Also, my guess is that we'll start to see some litigation on the B2B side too for unauthorized uses of customer data by vendors in order to train and improve their products.
That's right. I think both B2B is a risk and consumer data as well. So what has become sort of an increased focus by regulators is how companies who may use AI or develop AI for consumer-facing purposes are using data from consumers to train those algorithms and how they're notifying consumers about how to train the algorithms. And so there's been an increased focus by regulators on how privacy policies are changing for companies and where disclosures are being made about how consumer data could be used to train AI and consents around that. So I think that both the B2B and also B2C areas are going to be future risk areas and potentially a source of claims on the privacy side of the AI litigation landscape.
Right. And so as we're thinking about the input-oriented litigation, we're kind of thinking about that as its own category. But my guess is eventually that's also going to relate back to the output. So importantly, as we think about, okay, well, you used data inappropriately and that resulted in the training of an algorithm, and thus it was a violation of a privacy right or a violation of an IP right. That's one set of claims. You can imagine another set of claims whereby the training data itself resulted in some sort of bad outcome for the output, whether that resulted in the developer of an AI used the wrong training data, used inaccurate data, used data that resulted in a bias claim. Imagine there's a whole bunch of scenarios where the inputs of data may end up influencing the outputs of data, and then thus the claim may be that the output of data resulted in some sort of harm. Interested in your perspective as we start to transition into what we think the future claims would look like for outputs of AI.
Yeah, so I think you're exactly right that output litigation is going to be the result in part of what inputs were included to train the algorithm and improve the algorithm. And I think what we're going to see, which you alluded to, Scott, was a more diverse set of claims around output, both by private plaintiffs, by regulators, and that's because of the diverse and different use cases that large language models are having, right? So there's just going to be varied use cases here. Take healthcare, for example. AI technology is increasingly being applied to healthcare. They're using it for clinical research, they're using it for disease prediction or treatment. Some others are maybe using AI applications to predict surgical outcomes or to consider the likelihood of success of a particular treatment. And so I think you just take that use case alone, there's a whole host of claims that come out of that particular use case. Bias, for example, right? That is becoming an increasing concern within healthcare and the use of AI, and claims about bias and discrimination. Also, what flows out of that are potential product liability, negligence claims. So I think that it's going to depend on the use case, and there are a variety of claims within each use case that we could be seeing across the landscape.
So if I'm getting this right, then we're not really expecting just yet like an AI specific lawsuit saying you violated some sort of AI law, thus you are liable. It's more likely going to be the application of all of the existing means by which private parties sue each other in the United States, at least, for negligence or for product liability or for medical malpractice or any of the other areas where traditional liability has attached. That's going to be the focus or maybe the entranceway into this AI litigation.
I think calling it the entryway to this type of litigation is right. As you know, Scott, better than anybody, right? There's no federal framework for regulating AI yet, but there have been movements in the states in regulation of AI. And so I think it's going to be a little bit of time before those laws are passed, and some of those laws have private rights of action. So it is possible we'll see statutory-based claims. But I think you're right that what we're going to see at the sort of initial stages of this are some of the common law and other types of claims, product liability claims, claims for discrimination and negligence, potential libel claims based on the outputs.
Yeah, and I want to get into in a moment like how organizations should start to think about this in defending themselves or setting themselves up for a positive result in litigation. But before doing that, I think one theme that constantly comes up when we're talking about the development of AI law in the United States and even globally, it is very much, in my view, following the pattern of data protection. And I know one of the hats that you wear and one of the specialist areas that you've developed is around privacy and data-oriented litigation and the various different types of claims that plaintiffs have made, which may or may not be privacy claims after following a data breach or following a privacy incident in some way, in the same way that I think you're talking about it for AI. And I'm interested if you see that connection and whether that gives or provides a roadmap for organizations to see how AI litigation will develop in the United States.
I think that's a really good point, and I think it's a good question. I do think that some of the online privacy types of claims we've been seeing, or rather claims arising out of online privacy practices and claims arising out of cyber incidents in litigation, are going to serve as useful roadmaps, only because I think a lot of the same arguments that we make in those cases, like take standing, for example, lack of injury, are going to be key arguments that litigants are going to have to use to defend against these types of suits, right? Where was the harm? Where was the injury? It may be easier to show that depending on the use case, right? But I do think that those are going to be helpful roadmaps and helpful examples of how to navigate these kinds of claims in the context of using generative AI.
So, Vassi, I think that's a really good and important point. And as we start to maybe transition here and think about, all right, well, we both expect that there will continue to be lawsuits relating to inputs of data. We think there will be a whole lot more lawsuits relating to the outputs of AI. And so how should organizations start thinking about how they would defend themselves? So, for example, let's say you have a medical malpractice claim. You would think that a traditional defense would involve the doctor, the medical staff testifying as to the decisions that were made and the reasonableness of the decisions that were made for a particular treatment of a patient. Now, in the world of AI, if AI is making treatment-related decisions, are we expecting the computer to stand up with its right hand up and swear to tell the truth and testify in front of court? I'm just interested in thinking about where this is going to go.
Yeah. I mean, Scott, that is the key question here in a lot of this litigation and what companies are going to have to think about and grapple with in years to come. And I think what that question highlights is the need and the importance of truly understanding the system or the tool that you're deploying, investing the time and the effort and the resources on a cross-disciplinary basis to understand that tool, to understand its capabilities, its limitations, and all of the intended use cases. So paying close attention to the ownership and sourcing of the data that is being used to train the model, fine-tuning the prompts and the outputs, and of course, ensuring that you're following industry standards on safety and security and that you're operating and using the tool or the system in a reasonable way is just a starting point. It's not the answer to your question, but it's a critical place to start. And I think that the answer to the question is going to evolve just as the litigation evolves.
Yeah, my guess is that courts are going to be skeptical of some defense that says, well, I can't be liable because the AI told me to do it. And so that explainability point, I think, is probably going to cut across the litigation. And also, frankly, it's now one of the themes and keys that is coming up in these emerging AI laws. In other words, as developers and users of AI are deploying those tools, it's not the case that you can just go ahead and just, almost with blindfolds on, say that, well, the computer is now telling me what to do, and thus I can just follow it blindly. There needs to have the ability for humans at some level, but somewhere, to be able to explain how decisions were being arrived on and how the actual tool works. And that sounds like that's going to be a tenet of the regulatory apparatus that's going to apply here, and also the litigation that will inevitably follow.
I think that's right. And just a point on when you're thinking about the use of these kinds of tools or systems, and I would say a less serious context, right? So not the medical treatment or healthcare context, but perhaps, for fun, for use on an app or use on a website to interact with consumers. I think, of course, understanding the use case, understanding the capabilities and limitations is key, as we just talked about. But I do think that there's real importance behind disclosures to consumers, right? And we're not just talking about what's put in the privacy policy, but when you are interacting with a particular tool or model, making clear, even if you don't know all of the limitations or capabilities, that it's a little bit of a wild card, sort of proceed at your own risk when you enter the website or when you interact with this tool. And I think that is going to be, at the end of the day, a very helpful defense to rely on, that consumers consent to, potentially wild things that the AI spits back at them, right? And I think, again, it doesn't work in every context, but when you think about consumer litigation or claims around deception, for example, or false advertising, those kinds of things, those disclosures are going to be critically useful.
And so if I'm thinking then, Vassi, about maybe the next step here, because one of the ways that organizations are trying to get out ahead of these issues is developing and deploying an AI governance program that would be really focused in on how organizations can responsibly develop and responsibly use AI to try to address all of these risks. And, as you know, it is increasingly the case, at least with the United States government and the EU governments, is that if you don't document all of the good things you're doing, then you don't get credit for having done them. And of course, you wearing your litigation hat are going to say, well, be careful about what you document, because that will eventually become discoverable and may end up being used in connection with litigation. Interested in your perspective on how to bridge this gap of the need to document how AI is being developed and how it's being used versus inevitably thinking about that documentation as being subject to litigation or potential claims relating to the use of AI.
It's a bit of a delicate dance, and I don't think that there's a right answer. It's going to depend on the organization, the industry in which the organization sits and operates, the size of the organization, and what makes sense for that particular organization, right? Having a very thorough and extensive risk management framework, I think, is what us lawyers would recommend to our clients, right? Continually assessing and monitoring and managing potential risks around AI, doing regular updates and audits of AI, and keeping mitigation strategies in your back pocket and making sure that those strategies are aligned with legal and technological developments. And other organizations, they're innovating and they're smaller and they simply maybe don't have the time to put together such a thorough and manage such a thorough risk management framework and governance system. And so I think it really depends on the organization. I do think that there is a delicate dance between having a risk management framework or governance framework for AI and balancing that against what is potentially used as evidence in litigation for why certain controls were not appropriate for the risk. And I think one way to get around that, or one way to hopefully mitigate the risk of disclosure of that, is to ensure that when you're doing those sorts of audits or reviews that have the potential to be sticky and potentially problematic and could highlight some risks, that you're doing it under privilege, that you're doing it so that you're getting legal advice, that you're working closely with your in-house counsel or outside counsel to advise as to those risks. And, we can have the privilege fight later down the road. But I do think it's a prudent way to approach when you're dealing with a very innovative technology and potentially, never before seen use cases.
Yeah, really good point. I mean, almost one where it says you have to do it, but it's important that we have to do it right and have to do it in a very thoughtful way to think about making sure we're getting credit for all of the great work that is happening, while at the same time not creating unnecessary risks. Speaking of that unnecessary risk component, maybe I'm thinking there's a third category of litigation risk that we haven't touched on yet. So first one, inputs, second one, outputs. Agree on both of those. Is there a third that where I'm thinking about the many ways that AI is helping create new documentation and new records that will inevitably become the subject of a production request or a subpoena or, subject to a discovery. So for example, as you know, right, probably back in the 80s, you would probably request a lot of letters and kind of documentation that would be in hard copy. Now, a lot of the discovery requests relate to emails. And then when you add on emails on top of texts, like you start getting all sorts of information. And then, now we see these third-party communication tools that are increasingly being used and subject to discovery requests. It's almost like every time that there has been a new means and mode of communication that has resulted in some sort of digital artifact, it has resulted in an increased amount of discovery associated with litigation. And my guess is that AI won't be any different, especially as you are on video call systems and they give you the ability of having AI generated summaries of calls, or you are using AI tools to be able to summarize documents or summarize research. All of these artifacts that are being created, interested in your thoughts, are those now going to create new litigation risks in discovery?
I think the answer is yes. And we haven't seen that play out yet, but we will, right? Because as companies increasingly use AI and use it internally, right? So we've been talking a lot about external use cases and what that looks like, but especially as organizations use it internally, I think that's going to be a serious risk in discovery. And it's going to increase costs for a lot of organizations to be able to comply with discovery requests. And I think that piece also highlights the importance of how to educate and train your personnel on safe and responsible use of generative AI internally. For example, maybe if you're having a privileged conversation with your lawyer internally at the company, you're a stakeholder on a particular issue and you want to talk to your counsel, that you're not having, an AI tool record that conversation or take a transcript of that conversation, right? And so I think implementing regular and ongoing training programs, familiarizing employees with best practices for how to use generative AI, for how to retain outputs of AI used internally. And of course, the risk of that use is going to be critical here.
Yeah, I think that's exactly right. Well, maybe Vassi, I'd maybe conclude our podcast today, maybe with a final question. The difficult areas that are being created by AI, I think, has to do with the number of hats that AI lawyers need to wear. So, folks who are now responsible for leading AI initiatives within their organizations need to be spotting issues across a number of different disciplines, including litigation. So interested from your perspective, as litigators are kind of newly being asked to help their organizations protect against or plan for litigation relating to their development or use of AI. Any practice points or any tips that you would want to share?
Yeah, I mean, working with outside counsel is going to be important to do that because we have learnings that we've developed through conversations with clients across industries and clients that are using tools in different ways. And so I think doing a risk issue spotting type of exercise is a really good first step. And then thinking through whether it makes sense for that particular organization to operationalize those mitigation strategies that counsel identifies through that issue spotting exercise is going to be the next step, right? Does it make sense for that organization, for its risk posture, for its litigation posture, and to keep, that governance system strong, I think, as you continue to develop and evaluate your tools.
Yeah, I think it's a really key point that you made. In other words, as this is evolving and so many people are trying to figure it out and being asked to play a role that they've never been asked to play before, and frankly, where there's not really a playbook that has been fully established over the course of years and years of legal practice, that information sharing, that ability of accessing the expertise to understand how is it that you can approach these issues from a litigation, regulatory, transactional perspective, wherever, is super important.
Great. It's going to be an exciting time.
Appreciate your joining and sharing your insights on these really important and difficult issues. Thanks so much for joining the podcast.
Thank you, Scott. As always, talk to you soon.
With that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.